Okay, we are now in week 12 of Wills and Estates. We're going to be doing chapter 13 in the text. We're going to divide chapter 13 into two modules because there's a lot in here, where we're talking about the classifications of trusts, living trusts, all these special kinds of trusts. And so we're going to spend a little bit of time on these. Now, just so we have a little review, remember we have to have a settlor, a trust document or instrument, a trustee, and beneficiary in order for us to have a valid trust. And the settlor can be either the settlor and the trustee or the settlor and the beneficiary, but cannot be all three. And we're going to get into why that is in this chapter. Okay? Now, we are going to be sort of classifying all of these trusts. And if you look on page 441 of your textbook, Exhibit 13.1 kind of breaks down how we classify trusts. We're going to have active or passive, express or implied, or public or private, or testamentary or constructive. We've got all these classifications. So if you look at this diagram in Exhibit 13.1 as a guide as we start to talk about these, kind of at least it helps me mentally put everything in order. Okay? Now there's two big categories of trusts. There's express and implied. An express trust is one where we have a trust document, where a settlor is saying, I'm creating a trust. An implied trust is a little bit more nuanced. Usually a court will look at a situation and say, I know there's no trust document here, but out of equity, out of fairness, we are going to create a legal fiction and create one. And we're going to get into those situations later. We're really just going to deal with express trusts for right now. Okay? Now, express trusts can be private or public. And another way of saying a public trust is a charitable trust. So a private trust is one where the settlor creates specific beneficiaries. Okay? The settlor must intend to create a private trust. The trustee must be named to administer the trust. A trustee must be named, and a settlor must transfer sufficiently identified property to the trust. You can't have like an empty trust, okay? You've got to have something sitting in it, something identifiable, okay? Now, if I am giving something to my children or my grandchildren, that's a private trust, and it's for the specific benefit of those individuals. That's how I know it's a private trust. A public trust is different. A public trust is where I have what your book calls an indefinite class of people as my beneficiary. So if I leave money in a trust for the Red Cross is the beneficiary. I'm not naming Susie, Michael, Sam, who may benefit from what the Red Cross does. I'm simply leaving it to one large organization that will use the money and disperse it to individuals. You see charitable trusts a lot when we have testamentary trusts, which is a trust you create when you die, with some of the proceeds of your estate when you die. We do some of that for tax purposes, but we also do it because large organizations, large charitable organizations, actually solicit people to put into their last will and testament, a testamentary trust, where part of their estate gets left to this particular charitable organization. Okay? Why do they do that? Well, it's a great way to get a cash flow, right? If I am the Butler Art Museum and if I sit on the board for the Butler Art Museum, how in the world am I going to raise money? It's a free museum. How am I going to get new art to be able to come through? I'm sorry, I'm itchy today for some reason. How am I going to get new art exhibits? How am I going to pay people to work there? How are we going to pay security? What you do, if you are a large museum, in the arts, a ballet company, whatever, is you will set up a trust department. And there'll be a trust attorney or a probate attorney who will help people draft their last will and testament. And in their last will and testament, they will put a testamentary trust in there that takes effect when they die, so that a portion of their estate goes to whatever, the museum, the YMCA, whatever organization it is. It is a way to ensure that you have cash flow. And if I am putting together my estate plan, I would like to avoid some taxes. And one way of doing that is creating a charitable testamentary trust, because the amount that I put in will offset. It'll be deducted from the dollar value of my estate, so I'll pay lower taxes. Okay? Now, when you create a charitable or public trust, typically, you will create, as part of that trust, the trustee and the trustee will be a group of people. A lot of people, let's say that I pass away and I create a testamentary trust for what do I love? I don't really love all that much stuff that's charitable. Oh, no, that's not true. Let's say for the Heart Association, okay? I am going to, as the trustee of this trust, create maybe a 5-person board of trustees. And I'm going to insist in my trust document that 3 of the 5 need to be members of my family. My children, my grandchildren, whatever. Okay? Until I don't have any more heirs. Or at least one person on there needs to be someone in my family. Why would I do something like that? Well, because maybe I've worked hard. I want to make sure that my children know about charitable organizations and they contribute in their adulthood to that. Maybe I just want the money not to be wasted, right? People are very free with other people's money. But if you have a connection to it through the family, maybe you're a little bit more conservative with it. Okay? So typically when you put together a public trust, you will put in your trust document, hey, this trust will be administered by a board of trustees, one of whom will be one of my heirs, and then lay out what the money will be used for. Okay? The big thing to remember is public trust, charitable organization, not one individual that you're being named. Even though the organization is going to benefit individuals, the beneficiary itself of the trust is going to be some organization. Okay? Now, there is this thing called cypre, French, sadly not Latin. Cypre means as near as possible in French. Okay? And my French stinks. I have a terrible accent, but it's cypre. What the heck does that mean? Well, it's a doctrine that the courts will use when it comes to public trusts. Let's say that I create a public trust for graduates of What was the other school in Warren that went out of business? There was Warren Harding and Warren whatever. The school in Warren that was combined with Warren Harding. Okay. What if I create a trust so that scholarships will be provided for graduates of this particular high school? And the school district shrinks, and that high school is not there anymore. What do we do with this trust? What do we do with this money? Well, the courts came up with this Cypre doctrine that says, well, we are going to sort of put ourselves in the shoes of the settler and say, what would we want the settler to do? And can we make this work with Warren Harding students instead of the other Warren High School? It's close enough. The children from one school district are now into a larger school district, so of course it makes sense. One really good example of Cypre is March of Dimes. Everybody pretty much knows what March of Dimes is, right? March of Dimes, fight birth defects, right? That's what we think of today. That's not what March of Dimes was started for. A long time ago, the March of Dimes Foundation was set up to find a cure for polio and take care of children who had been afflicted with polio. Well, along comes Jonas Salk, and we have a cure for a vaccine for polio. Okay, mission accomplished, right? We don't need March of Dimes anymore, right? Well, had all this money for March of Dimes. People had donated. There was tons of money. What are we going to do with all this money? So March of Dimes sort of changed its focus to children with birth defects, which was close enough to polio because children who were afflicted with polio and survived, had paralyzation, were paralyzed. And so the court said, we're just going to continue March of Dimes, and it's going to be close enough, Cypre, to the old reason for March of Dimes, and so the trust will continue that way. That's Cypre. This is typically an issue where, you've got a ton of money. What are you going to do with it? What are you going to do with it? And you don't want to, you don't want to change what the settler really wanted, but you're sort of following the intent of the settler. Okay? So we have private, public. Then within those, we can have express trusts that are either active or passive. An active trust is where the trustee has to do stuff. They have to, buy and sell property. They have to provide money to a beneficiary. They have to do things. There are actually actions that the trustee must take, and the trust instrument tells them what to do. A passive trust is where the trustee is simply holding something. Typically, passive trusts you'll see when you have a trustee who's holding family heirlooms for a child until they turn a certain age, right? Maybe there's a wedding band from grandma that is put into trust, and the trustee must hold it until granddaughter reaches the age of 30 or something to that effect. Trustee doesn't have to do anything except hold it. They don't have to invest, they don't have to buy, they don't have to sell, they don't need to disperse funds. They're just holding on to it. Okay? Now, we can also have inter vivos and testamentary express trusts. Now we're starting to get complicated, right? Inter vivos, here we are Latin again, means among the living, while you're alive. I can create a trust while I'm alive. I can go see an attorney. I can say draft an inter vivos trust, and they will. And I can transfer property. I can be the beneficiary of it, right? I can have another trustee. I can be the settler and the beneficiary, and I can get the benefits of my stuff without actually owning my stuff. That's an inter vivos trust. Why in the world would I do that? And why would the government let me? Well, because trusts have a different tax rate than income tax, right? We have income tax rates that when you earn a certain amount of money, it goes up, right? Well, a trust doesn't have that same kind of income tax. They have a different tax rate. So I can own the same stuff, I can get the same income, but or I can get some income from the trust, but it's going to be taxed at a different rate. And that is where the benefit comes in. Also, I might create an inter vivos trust where I'm the beneficiary until I die, and then when I die, I put in the trust document that my children become the beneficiaries. And then I don't need a last will and testament, do I? Because all my stuff's already in a trust. I might have a last will and testament that says, hey, any stuff that I have, that I actually own, that I'm not just the beneficiary of a trust and using the stuff in the suitcase, transfer it into the trust. And then I don't need one. I can use the inter vivos trust instead of a really complex last will and testament. And again, taxes are the reason you want to do something like this. Attorney's fees, simplicity. Everything's already there. We don't have to read the will. We don't have to probate much. We don't have to worry about huge tax bills because I don't own anything. It's all in a trust. The IRS hates this. Just telling you. The IRS hates inter vivos trusts. So you have to do it by letter of the law. And there's no funny business with it. But it is an alternative for you. Now, what's a testamentary trust? Well, in my last will and testament, I can say, hey, create a trust for the Red Cross. It is my testament, right? My last will and testament, what I am saying is my wish, that I create a trust from whatever is in my probate estate. Well, testament turns into testamentary. Lawyers are not creative people, right? It becomes a testamentary trust. It's just a trust that I create in my last will and testament for whatever purpose. Maybe I create a testamentary trust for my minor children. Maybe I create a testamentary public trust to avoid some taxes, some probate taxes, because I'm giving to charity. Okay? Maybe I just create a testamentary trust so everything goes into a trust and the whole world doesn't get to see where all of my belongings go because my will is very vague. Maybe my trust is really specific and says these people get what I had. But my last will and testament basically says everything goes into my trust. Then the whole world doesn't get to peek into my world because your last will and testament is a public document. Again, I point to Ancestry.com. Where do you think they get all of their information? Public records. Your will becomes a public record. If you want to be a bit more private about things, you can have a testamentary trust like that. Okay? Now, there is this thing called the rule against perpetuities. Ugh, I'm just going to tell you, everybody who has ever gone to law school, if you say rule against perpetuities, they will roll their eyes. They'll say it's the dumbest thing I've ever heard in my life, right? The rule against perpetuities was put there because we don't want land to be tied up forever. The United States is different from Europe in that we don't have monarchs, we don't have royalty that can just gobble up land so the average citizen can't own land, right? If you go to Europe even today, it's hard to buy property because a lot of it is tied up with royalty. You know, the best land is already spoken for. Here in the United States, we don't go for that. right? So the rule against perpetuities, and I'm going to read it because I always get it wrong, that no interest in property is good or valid unless it must vest, take effect, if at all, not later than 21 years plus the period of gestation after some life or lives of being at the time of the creation of the interest. What does that mean? Within 21 years, somebody in your family's got to own this. Otherwise, it violates the rule against perpetuities. It's just land that's sitting there that the trust owns but not an individual owns, and there can be a problem. Someone can come in and challenge your ownership to the property. I have never seen anybody litigate the rule against perpetuities. It's just one of those things that every attorney out there is like, ugh, we had to learn it, but it's dumb. Just understand that 21 years plus 9 months after you create something, somebody's got to own it for an ownership in real property. Okay? Now, let's talk about these implied trusts. We've gone through express trusts, right? Express is where we have a trust document. It can be express or implied. It can be charitable. It can be private or public or private. It can be active or passive, right? And it can't violate the rule against perpetuities. It can be testamentary or inter vivos. All of those things. That's how we categorize them. So what is this implied trust where the court comes in and says, hey, I think maybe we're going to create a trust here, even though there's no trust instrument? Well, we have resulting and constructive trust. So resulting trust is created by an operation of law where one person becomes the possessor or holder of property with legal title but is obligated by the equity court to hold it in trust. Okay? Now, there are different kinds. There's a purchase money resulting trust where property is purchased for one person and the seller transfers it to another person. Okay? And what we'll do is we will look at the entire situation. There's something called the parole evidence rule. The parole evidence rule means that you don't look at anything outside a document, right? If I have a document there, it's called the four corners test or the parole evidence rule, where whatever's written within the four corners of that piece of paper, that's what we go by. We don't care what was said. We don't care what was negotiated. We look at the four corners. The parole evidence rule means we're going to stretch it because there's no document here, right? There might be a sales receipt, but we're going to talk about what was talked about. Okay? So look at this example that we've got here. Keith Andrews buys 500 shares of Honeywell stock with money that he needs to live. He instructs the corporation's agent to issue the certificates in the name of Carol Ann Heglin. Carol Ann is not related by blood or marriage to Keith, and in the absence of further evidence, Carol Ann holds the shareholder at shares as trustee in a resulting trust for Keith. Okay? What he's basically doing is trusting someone with the ownership of something that he needs. Lots of people do this with cars, right? Maybe somebody has terrible credit and they can't get a car loan. So they give the down payment, they make the payments, but they put the car in somebody else's name so it can get financed. And then the car gets paid off, and the person that has the title to the car is like, hey, thanks for buying me this car. And they're like, no, I need that car. I paid it off. It was my down payment. It was, the loan might have been in your name, but I made all the payments. Really sorry. Not going to do that. Okay? A failed trust is another kind of implied trust. So let's say that I create a testamentary trust and and the trust fails because there's no money. What do we do? Let's look at the example in the book. Angelo Rossi conveys his farm to Oakburn by deed to, Angelo Rossi conveys his farm Oakburn by deed to Hunter Jennings in trust for Lance Anderson. Unknown to Angelo, Lance is dead at the time of the conveyance. The trust property now reverts to Angelo, but until Angelo takes possession of it, Hunter holds Oakburn in the resulting trust for Angelo. Okay? So if I am going to give somebody something and they can't take it, then it reverts back. And until it reverts back to the original settler, in that limbo time, there is a resulting trust. Okay? Now, a constructive trust. Constructive trust is usually where people are trying to get one over. I know it's terrible. Again, I did divorce law for a really long time. And people would transfer, I always use the snowmobile because it always was a snowmobile. Transfer the snowmobile to the brother-in-law and says to the brother-in-law, hey, keep this until the divorce is over and then give it back to me. And the brother-in-law says, sure. And then the divorce is over and the brother-in-law is like, I have no idea what you're talking about. Constructive trust. The brother-in-law was holding that in constructive trust for the guy getting the divorce. Now, it's illegal. You're not supposed to do that. Happens all the time. Happens all the time. People in the military who go to war. I'm going to transfer the car to you in case I don't come back. But if I come back, you give me the car. Right? You transfer it back to me. Believe it or not, people will say, no, you gave me the car. The courts have to step in. This is why we say it's implied, because the court steps in and says, nope, really not going to let you do that. Okay? All right. I'm going to stop there, and we will pick up with some miscellaneous kinds of trusts, some different kinds of trusts that we use, and they have specific purposes. Okay? If you have any questions, please feel free to call me. Do your discussion and do your assignments. Okay? Thank you.